2, 1.
Well, good morning, everyone. The Supreme Court of Texas convenes an administrative session for public deliberations on proposed amendments to the Texas Disciplinary Rules of Professional Conduct and the Texas Rules of Disciplinary Procedure, approved by a majority of votes cast by members of the State Bar of Texas in a referendum several weeks ago, as certified to the court by the State Bar's Executive Director. The proposed amendments have also been approved by the Committee on Disciplinary Rules and Referenda and by the State Bar Board of Directors. The State Bar has requested the court's approval of the rules. The court invited public comments. No comments were received. The court gave notice of these public deliberations, which are being conducted by Zoom video conferencing and broadcast to YouTube for public viewing. Several members of the Committee on Disciplinary Rules and Referenda and leaders of the State Bar of Texas will make presentations to the court and respond to any questions by members of the court. We appreciate the presenters' work on these rules and their appearances today. We'll begin with remarks by the Executive Director of the State Bar of Texas, Trey Apfel. Mr. Apfel.
Thank you, Chief Justice Heck and members of the Supreme Court. May it please the court. We come to you today on behalf of the State Bar of Texas and the Committee on Disciplinary Rules and Referenda to present the results of the 2021 rules referendum and to explain all of the ballot items that were voted on by State Bar membership. Our request to the court today is for the court to approve each of the 8 rule proposals presented to you here today. Subchapter E1 of the State Bar Act spells out the process for how the Texas Disciplinary Rules of Professional Conduct and the Texas Rules of Disciplinary Procedure are to be amended. This is a new process created by the Texas legislature, and it became effective in 2017. As you know, the act created the Committee on Disciplinary Rules and Referenda, or CDRR as we refer to it. CDRR's role is to regularly review the rules and oversee the initial process for proposing a disciplinary rule. There are specific deadlines that must be followed, along with requirements for public comment. For a proposed rule to be adopted, the statute requires that it be approved by CDRR, the State Bar Board of Directors, State Bar membership, and finally, the Supreme Court of Texas. We are here before you today at the last stage of that process. CDRR has been meeting monthly to conduct its work. They have conducted public hearings and considered many public comments. Proposals were published in the Texas Bar Journal and Texas Register, and a CDRR website was developed to share documents and meeting materials for the general public. Emails were regularly sent to the State Bar members and others to notify them about rule proposals, public hearings, and opportunity to submit comments. All CDRR meetings are open to the public. It is a very transparent process that gives attorneys multiple opportunities to provide input. Over the past 2 years, CDRR has submitted proposed amendments to the State Bar Board of Directors. The board's DCAP committee has reviewed each proposal and made recommendations to the full board to approve them. At meetings held between April 26, 2019 and September 25, 2020, that's an 18-month spread, the Board of Directors voted to approve each of these rule proposals. On September 28, 2020, the Board of Directors petitioned the Supreme Court to submit the proposed rules to members of the State Bar for a rules vote referendum, and that vote took place from February 2, 2021 through March 4, 2021 by both electronic and paper ballot. On September 29th, the court issued its order directing the bar to distribute the ballots for the rules vote. The State Bar conducted an extensive effort to educate lawyers about the proposals. Beginning in January, we conducted 4 rules vote CLE online forums where members of the CDRR committee explained each of the proposals and answered questions from the audience. In addition, we published information in the Bar Journal, the State Bar of Texas podcast, and on social media. And we sent emails periodically to our membership. CDRR members also made numerous presentations to local bar associations and other groups. Given the pandemic conditions that have existed over the last 14, 15 months, we believe we did as much as we possibly could to inform our membership about the rules proposals. In terms of the rules vote, the State Bar distributed 106,760 ballots and 19,823 attorneys, or about 18.5% returned ballots. All 8 of the ballot items passed overwhelmingly, with each receiving at least 78% of the vote in favor of the proposal. We submitted the official results of the ballot items to the court on March 5, and they are included in your materials. We believe the proposals are sound, certainly well vetted, and they represent good public policy that will serve to provide clarification and modernization for attorneys and ultimately protection of the public. I am joined by Louis Kynard, the chair of CDRR, as well as CDRR members Claude DeClue, Vincent Johnson, and Bar Counsel Brad Johnson is also on hand. We'd like to thank the court for its consideration of our request for approval of these rules. And unless there are any questions, this concludes my opening remarks.
Any questions of Mr. Apple? Thank you, Mr. Apple. We'll go then to the first item, which is the scope and objectives of representation, clients with diminished capacity, presented by the chair of the committee, Mr. Louis Kynard. Mr. Kynard.
Thank you, Chief Justice Hack and Trey, for those remarks. It's great to be here today, and we're going to roll right into our agenda, starting with ballot item A, which you probably have seen in your materials, moves and amends a provision that is currently in Texas 102G, which requires a lawyer to take reasonable action to secure appointment of a guardian or other legal representative when the lawyer reasonably believes the client lacks legal competence. We adapted the ABA language on this rule, which was actually presented. This is the only one of the items that was presented in 2011, very closely to that. It gives lawyers a lot more options. So you don't have just zero or guardianship now. You have now reasonable action that can be taken based upon the circumstances. And the lawyer now has a range of tools available to them through 1.16 of Texas rules, disciplinary rules.
Mr. Kynard, I have a question.
Yes, ma'am.
So let's assume that the lawyer is using objective criteria to make this decision rather than their own subjective opinion. They're basing it on expert testimony, the things that a court would rely on in terms of making a fair and accurate determination. And the attorney determines that this client does have diminished capacity, as we have always called it, or lack of capacity. Why? My concern is that now that this is discretionary rather than mandatory, that the client could be left without protection. So what is to prevent that from happening under these rules?
The real trick is that we can't force a lawyer to be a mental health expert. So knowing I'm
assuming, I understand that problem, but I'm assuming that the lawyer has used objective criteria, and that doesn't mean their own opinion about what's right and wrong. That means objective criteria to make this determination. It seems to me that if that's the problem, that we don't want attorneys to be acting as experts, which I wholeheartedly agree with, it seems to me that we would structure rules to help them make sure this determination is objective, rather than leave the public in a situation where they may be unprotected.
See, that part hasn't changed. It still is reasonable belief. Reasonable belief is in the current rule. Reasonable belief is here in this language as well. So
It's the shall language that I'm concerned
yeah, but
about.
it still says when reasonable belief. So it's based on a reasonableness test of the lawyer's perspective of those facts and circumstances for that client at that situation. So I think that standard is very much the same.
But why wasn't that changed? That's always been the problem, is the lawyer substituting his or her own opinion about what should happen here, rather than relying on objective expertise.
Because the lawyer is in the best position to assess his or her client and whether they are losing capacity to support their own representation. This isn't about, being appointed to represent someone who already is in that state, but this is about, a progression of diminishment, and the lawyer needing to at least say, hey, your Uncle Joe may need to talk to his doctor about his medications, and not much more, but being able to do that without going straight to a guardianship, which left the lawyer with very little to do. In fact, left most clients with very little help and protection, because if the lawyer chose between an adversarial proceeding like guardianship and nothing, most of the time lawyers were choosing nothing, which is why the probate bar had requested we bring in the ABA rule.
So what language in the rule directs us that it does not apply to appointments?
It allows that, but it allows everything in between.
No, I mean that the lawyer.
Because it talks about a client, so you have to already be the client. So it's not establishing a attorney-client relationship. It's when you have already become the client. So the rule is addressed at the client-lawyer relationship after it exists.
So perhaps you all could make it clear that it does not apply to appointed attorneys, since that's what apparently
we can look at those comments. And that was another thing I was going to mention, that during the vote process, we've gotten additional constructive comments, and we're going to decide on tomorrow and submit to you pretty soon, because there were a few really good points made by practitioners in this area, and tweaks to the comments seemed appropriate based on those. But that we can look at that one as well.
Right. Thank you.
Mr. Kynard, as you're looking at the comments, I had a question about comment 4, and there's some language there in quotes, trusted person. Does that have a definition? I wasn't sure why that was in quotes, or what whether that had some sort of independent meaning.
It isn't defined, and it was used in quotes to basically indicate that that's sort of a colloquial concept. So the basic thing is you can't always know who that trusted family member, friend, coworker, employer, somebody that the client trusts. And you can't always rely on it being a family member. So we know a lot of times family members are not the trusted people. So the idea is that the lawyer needs to talk to someone with discretion and with very limited disclosure, and who that is has to be assessed.
It might be helpful to take those quotes off if it's not a defined term, just so people know not to go looking for it.
Good one.
Well, it's even a little more confusing than that, because it says previously designated trusted person. And I'm wondering how someone's supposed to have designated a trusted person. And I thought, when I read that, I thought maybe there is some common procedural tool that's used in certain practices or something, but I guess that's not the case.
No, I think you actually named it exactly. There are a lot of lawyers who ask during an intake process who a reliable family member or trusted person may be, someone to contact in the event of an emergency. And I think the probate bar has a stronger practice here than others, especially dealing with elderly people that may need to know who they can ask. Is that really, where the title is kept in the jar under the reports or something. I mean, those types of things that some lawyers are very diligent at asking for that. Who do you trust? Who do you know? Who would you designate? And perhaps it's already in their will as the executor, the heirs, guardians, and alternatives. We think that this is an improvement. Again, the probate section is where the request came from. They have re-urged it since the 2011 vote. It passed very overwhelmingly, and we believe it's really going to assist lawyers in assisting clients, which is the real goal of this rule. I'm going to hand this over now to Claude. Is that right? Claude Decloux is going to present on item B.
Thanks very much. May it please the court. And let me add on what Louis was saying. I'm Claude Decloux, and I thank the court for appointing me 4 years ago to this. And we've worked very hard every month on this. And it's been a joy and a mission as someone who's probably started out my career prosecuting lawyers for disbarment, and now probably having represented 500 lawyers. This is a real opportunity to provide new tools. And that's how these three rules, I want to address what Justice Lehrman and Chief Justice Hecht and Justice Buzzy were talking about. This first rule that he was talking about is for an existing client. If you have an intake and you realize this person doesn't realize the scope of their, you have serious doubts about it. But this is the typical lawyer who's been practicing for 20 years, and Bob comes in and forgets that he's inherited this property. These are all tools, as we say, to crack the cone of silence just to the minimal extent to make sure you're protecting that client. If the client comes in and says, I want to sell everything and buy a submarine, you don't immediately disclose that. You say, I'm not sure that has Bob changed his medication? What's going on with him? It's just to alert the family that you have concerns about this. If he wants to come in and change his will, this does not give you permission to say, hey, your dad came in and wants to cut you out of the will. No, this is minimal to say, I'm not sure that he understands our conversations anymore. Can you tell me what's going on? And it's not to help you, it's to help that client. And they're wonderful, I call them tools in our toolkit to help our clients achieve their legal rights and goals. And as to the forms, Justice Busby, that you were talking about, yes, believe me, we have already been drafting some forms that say, assuming this rule gets passed, you have a right to designate a trusted person and explain that. And you don't have any duty to, but if you would like to do that, that would give the lawyer the opportunity to consult with that person to a minimal extent if there is something like that. So we are really carefully wording that to abide by this rule. The second rule that I'm talking about is very, very simple. Everyone already assumes, and I certainly have since I've done this 500, that we have a right to reveal confidences to an ethics person, a lawyer who specializes in giving ethical advice. Well, all this does is tie down that little, nail in the carpet saying, yes, you may crack that cone of silence enough so that you can get ethics advice. I have these two clients and they do this and one appears in front of this, but there's a competing board, or they want the same piece of, what do I do? Do I have a conflict? And again, the rule minimally allows you, when I do that, I always say, first of all, I'm bound then as your ethics advisor, I can't reveal anything that you told me. So the first thing I do with a good interviewing technique is, first of all, who does this involve? Because I want to make sure they're not my own clients. Maybe as a younger attorney, you don't have many, but after almost 44 years of practicing, I have many conflicts of interest. So I always ask, well, and this just makes it clear, yes, you can get ethics advice, and your ethics advisor, again, is bound by that same, confidentiality. But you may reveal as much as you need to reveal to get an effective ethics opinion. That's really all this is about, and it's a wonderful new tool. It's just seals that right to get ethics advice.
Mr. Decloux.
Yes.
So thank you for presenting this rule. You just mentioned that the person to whom you go for ethics advice is also bound by the confidentiality of the information you've provided to them.
Yes.
I didn't see that in the rules or comments anywhere, and I may have missed it, but is there any reason why we shouldn't say that in the comments of this rule?
No, I think that would be a wonderful thing to tie down, because you do, if you're going to reveal confidential information, that person needs to be bound by that same confidentiality now and in the future, you know. So I don't see any problem with nailing down that in the comments.
Any other questions?
And
Thank
I'm
you.
happy to provide. I've probably given 30 CLEs since November on this, so I'm waiting for a question that I haven't heard before. So if you want comments, please feel free to ask me questions.
Thank you. Well, we'll move to the third topic, confidentiality of information, exception to permit disclosure to prevent client death by suicide. And I believe Mr. Vincent Johnson is going to present that. Mr. Johnson?
May it please the court. This is a small housekeeping matter. It would bring the confidentiality rule up to date with regard to a major social problem, and that is suicide by persons who have been in the military, suicide related to the pandemic, suicide related to opioid crisis. And so what this provision would do is it would allow the limited disclosure of confidential information for the purpose of preventing the client from dying of suicide. This is simply optional. It's not mandatory, and it is no broader than necessary. The disclosure of confidential information would have to be reasonably necessary. And the thought is that this would help lawyers to respond in a humane way and prevent some crises that could be averted.
Questions of Mr. Johnson? Thanks very much for your presentation. We'll go to the next item, assignment of judges in disciplinary complaints and related provisions, again by Mr. Duclue. You're muted, Mr. Duclue.
I assume I'm unmuted. Thank you, Judge. Yes, this again is actually came from the court. As you know, and I guess I'm one of the few people who've actually handled these cases, we've always preserved the lawyer's right to ask for a jury trial in a disciplinary conduct case or a disbarment case where he can ask for the assignment of a judge. Well, in the early days, 40 years ago, it was handled by your local district judge. And of course, the judge knew all the lawyers in the county. Well, they fixed that years ago by saying it needs to be a judge out of the county. And the current rule has two issues which the court wanted to correct. And that is, the first issue is, you know, the court pretty much has to just pick a name out of a hat. And suddenly a judge from Wichita Falls is having to go down to Houston to hear a disciplinary case, and she's not very happy about that. So they said, you know, can we make this a little bit better? The second one is that it had its own recusal procedure, and it really didn't need, and it was at odds with the rules of, you know, the rules, the civil rules. So we said, why not fix this? So when the court said, could you help us get a better rule? We went, of course, to the Chief Disciplinary Counsel, and she and I drafted 3 different alternatives. And as we vetted them all, we thought that this rule was the best way to do it. And that's allowing the presiding judge of the entire judicial district to take a notice of all the judges in his or her district and say, I think this judge in an adjoining county would, and they could actually consult with that judge and call her and say, do you have time to hear a disbarment case down in Travis County? And actually find the appropriate judge. Better yet, of course, the respondent, their rights are all still preserved. If they say, oh, no, I don't want that judge because she used to be law partners with the person who, whatever the reasons. But now we made it clear under the new rule that recusal is just under the rules of civil procedure, the same process you file the same motions, and it doesn't have its own unique procedure. It's a lot more flexible. It gives the presiding judge of that entire administrative judicial district the right to say, yes, I think this would be an appropriate judge, and it still preserves the right to recusal. So it's an improvement. We did, of course, on everything. You know, not everybody likes everything, and some people just don't like it because they don't like it, because they, you know, whatever. But overall, it was been, I think, very well received by the public. And of course, it has very minimal impact in that, and I don't know, the court will know better, but my understanding from looking at this, that very few lawyers now choose to go to a jury trial and have everything, all their laundry out there in the public, when the committee procedure is much more secure and confidential, and they can work out a lot more settlement. So there's not that many. I would imagine there's less than 24 of these orders a year that are going to be affected by this process. It's just a better rule of disciplinary procedure. And I wanted to make that clarification. This is not a rule of disciplinary conduct. It fixes the current rule of disciplinary procedure.
And the regional presiding judges are okay with that?
In fact, yes. During the judicial conference, they vetted this rule and they looked at the alternatives, and they reported back to us, yes, we like this version the best.
Any other questions? And then I think you have yet another topic, Mr. DeClue.
I do, Your Honor. Again, this is very, very important. Let me give you a little background on this. We're facing a little bit of a crisis of lawyers retiring without making any preparations. The ABA predicts that in the next 10 years, more than 50,000 judges will just come in and drop the keys on their desk and say, I'm done. And they will have made no plans or procedures and that's going to be, and I have already personally helped close down 3 law practices where this happened. One of them was where a lawyer tragically died. Another one where a lawyer got another serious debilitating illness. Now, if you're in a big firm, it's not going to matter, but the small firms and the solo practitioners, that's really an issue. Now, for 25 years, we've had this wonderful rule. Again, this is a rule of procedure, not conduct. 1303 that says, great, you can go to the a district court in the county of the lawyer's practice and have various custodians. Now, remember, a custodian is different from an attorney, in fact, appointed by, appointment, because a custodian, when they're appointed under Rule 1303, they get sort of Good Samaritan protection. That they, if I'm appointed by a judge to help close down John Doe's practice, as long as I don't embezzle his funds or make some serious intentional misconduct, I'm protected from lawsuits. My job is to close down the practice and, hand out money out of his trust account that's owed to clients and things like that. Well, that's great, but it still involves a judicial procedure. So they passed a resolution. Why can't we have a voluntary rule where we can voluntarily appoint a custodian with that same Good Samaritan protection, as I call it? So I crafted the rule a year ago, last November, for a committee of the State Bar to look at. We, completed it, vetted it, sent it out. It's again a wonderful tool, because now lawyers will be able to, without having to go to court, appoint custodians, and they can appoint more than one. They say, I want Mary, who is also a CPA, if anything happens to me, to close down my accounting and my trust account. But I want Bob, who knows all the, trial lawyers in the county, to hand out my trust. So you can appoint more than one, and they all, because of this rule, will have that Good Samaritan protection, as long as they're not, stealing your money or doing something like that. The other thing is, we wanted to make this clear. They wanted to expand. I said, no, this is really about closing a practice. They say, well, what about if the lawyer is just going to be out for 6 months? I said, well, then if you're a custodian, you're practicing law. You're not closing down the practice. You're trying to keep files open. And that's a different, we may see if a rule like but that's not what this is about. This is for somebody, a situation where the lawyer says, if anything happens to me and I can't do it myself. Now, I want to mention also to the court, and I'm sure many of the court members already know this, you can already designate a custodian on the State Bar website, just a general custodian. And when that came available about a year ago, I went and I designated my old law partner, Aaron De La Garza. I said, if anything happens to me, that I'm not planning to go anywhere. And then of course, when I designate it, the State Bar automatically sends an email to Mr. De La Garza and says, Claude Duclos has named you as his custodian. Do you accept that appointment? Fortunately, he made the bad decision, said yes. But at any rate, so you can do that now. But this is a wonderful, helpful tool for lawyers to make some plans if anything happens to that lawyer, to have custodians. It's going to be a wonderful tool, and it passed by 95% of the people voting. I'm pretty sure it's close to 95%.
Any
Mr.
questions?
Chief, I do. So
Just
I know, so the custodial lawyer may need to file a motion to advise the court and seek a continuance on something that's coming up, a hearing that's coming up quickly or something. And I'm just wondering how the rule accommodates for that, what could be a pretty fuzzy line between, I mean, I can kind of see a situation where a judge who's constantly scrambling to maintain her docket does not want to grant a continuance and says, well, counsel, you've appeared on behalf of the client, so we'll see you, 2 weeks from Monday for trial. How does the rule accommodate that? Is it anticipated there'd be a particular kind of form or title that the lawyer appears as to clearly indicate the limitation of their role?
Your Honor, this lawyer will not be substituting in for cases at all. If the judge wants to make a dead lawyer go to trial, I have to say in the 3 cases I've been involved in, the judges were extremely cooperative and happy that somebody had been appointed as a custodian. They don't treat us as we're counsel. We're not stepping in for that party. We're closing down that lawyer's law practice. And I guess there maybe will be a judge who suggests that a dead person come to trial, but we don't substitute in as a custodian.
And I'm just making sure that you're comfortable that the rule and comments protect the lawyer in that circumstance, that the judge cannot treat this custodian lawyer as having responsibilities beyond that very limited scope.
Yes, Justice Boyd, that's why I made that point. One of the points was we crafted this to show, no, you're not stepping in and practicing law. You don't have the fiduciary duties if I appoint you as my attorney. In fact, that's fiduciary duty. This is custodian duties. It's different. This is, thank goodness we have someone to hand out the files, call the clients, let him know that so-and-so passed away or is unable, is completely disabled, had a stroke. And you're not stepping in the shoes of that lawyer. You're not practicing law. You're a custodian for wrapping up that lawyer's practice.
Do you think the comments adequately convey that?
We'll take a hard look at that, Justice Lehrman, because I agree that there's a lot of things that we always can. Every time we look at these, I think we improve them. I think when you get to talk to Professor Johnson about the advertising rules, he and I and Amy Breslin worked on those for 18 months. We probably exchanged commas, 60 times in 1 or 2 rules. So we'll do our best to improve those and make that sure, Justice Lehrman.
Thank you.
Any other questions?
I have one, Chief, or perhaps it's a suggestion for addressing a scenario that has come up in my mind in comments, if that would be helpful. And I'm positing a situation where a lawyer determines that he needs to make a disclosure because the client has diminished capacity, but there has not been a form to designate a trusted person. How does the lawyer decide if there are family members with maybe competing interests? How does the lawyer decide to whom to disclose? And is the lawyer protected if one family member or the client comes back and says, you shouldn't have done that?
Well, that's where the comments and instructions will come in very helpful. Again, Justice Huddle, this is not to reveal confidences. It's not to tell them, hey, he came in and he wants to do this and he's going to sell your car or send. It's to say, I'm not sure that this person understands it. And again, this is for an established client, not someone who just walks in off the street. So you're going to know, generally speaking, even if they haven't designated a trusted person, if that person has a spouse, and clearly they're not getting divorced, and clearly if it's a divorce situation, you don't want to call the spouse at all, or a son or a brother or a law or whoever it is. And again, it's not mandatory. If you don't know who that is, you might have to just default to the rule, say, I think I need to recommend that we have a guardianship for this person. If there is no, you still have the right under the rules as they are now to say, I think guardianship is important because there's nobody for me to talk to, and I don't think my client understands anymore.
Any other questions? Thank you, Mr. DeClue.
Thank you.
We're running a little ahead of schedule. We have a break, reset scheduled, but I think we'll press on unless there's objection on the court, and go to the next item, which is conflict of interest exceptions for nonprofit and limited pro bono legal services. Again, Chairman Canong.
Thanks, everyone. The history of this provision dates back to Hurricane Ike, if you might remember that. Shortly after that storm, lawyers from Lone Star Legal Aid and Houston Bar Association trained a lot of young lawyers who were eager to go out and help the victims, learned the nuances of fallen fence law and what to do if your neighbor's boat or house wound up in your front yard and they don't have any insurance. Just a lot of things that most of us didn't get in law school. So we trained rooms full. I was one of those trainers. We built manuals, we equipped them, we got them ready. Did go up at the disaster relief centers, and come to find out a lot of the fear of imputed conflicts of interest. So they thought that the no good deed goes unpunished rule would come back and hurt them. Their law firms didn't want them out there taking the risk. A lot of financial issues on the table. This is a rule that the ABA adopted years ago. And in fact, a member of the bar in Houston requested previous committee, the bar's committee on disciplinary rules, to take this up. It was a little late for the 2011 package, which may have been a good thing, but it still has left Texas without this type of very limited, narrow exception to those imputed conflicts of interest rules. As you can see,
we've lost your video, Mr. Kiner, and audio both. You might check your signal, or might need to get back on.
Chief, it looks like he's having difficulty connecting. We might want to move to the next item. He just dropped off.
All right. No, here he is.
Justice Hecht, I'm glad to fill in. Oh, he's back. He's back.
all right, I've reconnected. Hopefully that works this time. So not sure where it cut off, but I would just say that the keys are the definitions. It has to be a program provided through a qualified LSC or Texas Access to Justice or Bar Association sponsored event. The services have to be extremely limited. What form do I use? What do I put in this blank on my FEMA form? What do I do? Is there any right? Do I have a responsibility? And you cannot know of a conflict. It can't be something that you actually know. So this is an exemption from unknown imputed conflicts, not actual direct conflicts of interest. There are several ways that it's defined, and also if you look at Part C, it talks about the unique position that legal service services providers or civil legal services providers are in when they are very for civil legal assistance. Through all the consolidations that happened about 20 years ago, we're down to just one. Looks like I'm frozen again.
You're in and out. You're in right this second.
Okay, so happy to take questions on this, but I think this is one that's been needed in Texas for some time, and that's an area I've personally experienced as a strong need, both in the general disaster relief and in the avoiding the false conflict of interest scenarios that C addresses.
Any questions?
I have one, Chief, and I appreciate the committee's work on this and all the rules. Y'all have worked very hard on this, and it certainly shows. And this one in particular, I think, is going to be a really big help for access to justice and encouraging people to take these kinds of limited representations. I just wondered about comment 8 on eligibility. You were just mentioning the financial information that people have to provide to ensure they're qualified for some of these services. And it says on the second to last line, but no legal services are provided. And I was confused by that because I think in most of those cases, if you're providing financial information to ensure that you qualify, there will be legal services provided, but they may not be provided by the person to whom you provided the financial information. So I just wondered if y'all might take a look at that language and see if you could clarify that, because it tripped me up. I'm not sure I understand what it's doing there, and I didn't see anything about that in the rule itself.
Certainly, I think the goal is to segregate the eligibility screening from the actual creation of a lawyer-client relationship and delivery of legal assistance, so that if the programs put the proper structure in place, they can fence that part off, and it's not a wall, so to speak, but it allows them to contain that information, such as especially the bad faith prospective client who's trying to disqualify their, let's say, domestic violence victim from getting free assistance by throwing their information out there onto an application, and therefore disqualifying both sides from eligibility because he or she, primarily he, was well over the limits and they knew it. So the idea is that if you haven't done anything, you have just taken their application and determined that they are nowhere near eligible, then that should not create an automatic disqualification of the other party. There's also that provision that they can set that in the intake process that says, by applying, I agree that in those situations, it won't create a conflict.
And those all make sense to me. I think that if we could maybe sharpen the comment to focus on those scenarios, because the way I read it, if the information is provided to Lone Star Legal Aid or one of the legal aid organizations, and they determine that somebody's eligible through one of these clinics, they then can't provide the services, and maybe nobody else can either. So I certainly understand the scenarios that you're wanting to focus on, and I think that's just right. But I just want to be sure we're not precluding anybody else from providing services.
We'll take a look at that, Justice Busby. Thank you.
Any other questions? Thank you. Now, Professor Johnson, I believe we go to you on information about legal services, lawyer advertising, and solicitation.
I'm getting a message here that the host has stopped the video, so that may need to be turned on. What we have here is a complete new package of rules related to advertising and solicitation. So it is a group of 6 rules. It tries to put together a coherent architecture that is easy for readers to follow, and that answers the questions that lawyers would normally have with regard to these subjects. the big picture is that this package of rules, advertising and solicitation, it's very much mainstream. Or you look at the ABA model rules, or you look at the Supreme Court decisions, what we're proposing here is something that is very solidly anchored in all of those bodies of law. What we were trying to do was to simplify, modernize, and clarify the advertising and solicitation rules, and to do that in a way that would reduce the burdens that are imposed on lawyers who are busy operating law practices. And so where possible, we simplified. Where possible, we eliminated filing requirements. Quite importantly, we addressed specifically issues related to the digital age. And so how the anti-solicitation rules apply to online communications with a prospective client, or how they relate to the restrictions dealing with advertising, how they apply to advertisements. So what we have are 6 rules, and what I'd propose to do is just walk you through the 6 rules and hit the high points, and I'll be happy to answer any questions that you have. We did give this a very great amount of attention over the first 3 years of the Committee on Disciplinary Rules and Referenda. We redrafted the entire package at least 3 times, and we paid very great attention to the public comments that came out of the public hearings or that were submitted online, and we tried to tweak little things that were important to segments of the bar and that might have gone without appropriate attention.
Mr. Johnson, let me ask you, of course, there's the big issue about trade names, and we have First Amendment concerns, obviously, that are being addressed by federal courts. And so I understand that your hands are tied to a certain extent. But having said that, what precautions are made, to keep some lawyer from advertising something to the effect of, I am, come hire our law firm. We have the expertise that's the best in the world, and we can do blah, blah, blah for you. And this is communicated to people who really don't know and may be relying on something that's not a true representation of the facts. So are there any ways to protect the public against that?
2 things come to mind. The first would be that we have placed in the first rule, 7.01, a very clear statement of the constitutional touchstone for this entire area of the law, and that is the statements that are false or misleading can be prohibited. And so that rule, which is critical at every turn, it's right up front so that it doesn't get lost. And then the second thing that comes to mind is that this is where the resources that we devote to the disciplinary process then call on lawyers who have gone too far to account for themselves and impose discipline. And so it will be a process of education, and we've tried to make the rules as easily understandable as possible. And so through good education, through vigorous disciplinary enforcement, we will probably come as close to the result that we would like to see as possible.
Mr. Johnson, in communities where communications are made in a different language, for example, Spanish, do you see enforcement as being a greater issue, just being a native Spanish speaker I, even under our current rules, sometimes see advertisements and attempts to engage the public that, in my view, aren't necessarily appropriate. Do you see a scenario where this will become a bigger problem when communications are directed at communities that are non-English speaking?
I think you're very thoughtful in raising that issue. I think there are special concerns. I assume that if this package of rules is put into force, that there is going to be a great deal of resources that are spent on re-educating Texas lawyers. And I think that would be one of the issues that should be addressed. So the impact on communities that where Spanish or some other language than English is common. So I think we will have an opportunity to address that in the educational efforts that will come along with the new rules. I think that the State Bar Advertising Committee, with which certain advertisements need to be filed, that they're going to be allocating their time differently than they have in the past. And that's because we have greatly simplified the regime. And this will be an opportunity to consider whether their resources have been appropriately devoted and to make changes if necessary. So I think that we'll have the opportunity to think about and to address those types of issues. So on Rule 7.01, so we start with constitutional prohibition against false or misleading statements. We do something that you would have thought would have past 40 years, and that is to put clear definitions of advertisement and solicitation communication in Rule 7.01, because we refer to these different modes of communication all the time, but it would really help to have a working definition. And so we have defined those terms: advertisement on the one hand, solicitation communication on the other hand, and they drive the subsequent rules. 7.02 is a rule about advertisement. 7.03 is about solicitation communications. And then quite importantly, the way we have defined advertisement and solicitation communication is that to fall within either category, the communication has to be substantially motivated by pecuniary gain. And if that's not the objective, which would be true in the case of legal services for the poor, that then whatever is stated in those subsequent rules on advertisements and solicitation communications, it just drops away. It's something that those lawyers who are providing legal services to the poor do not need to worry about. The only thing they need to worry about is that first rule right at the front, and that's you can't be false or misleading. And then as a result of focusing on that constitutional principle, that's essentially why we come out where we came out with regard to trade names. Trade names are permissible unless they're false or misleading. That is the overwhelming position of states nationally. The old prohibition against trade names is almost entirely gone from American law, and with this change, Texas would follow the national trend, which is anchored in constitutional jurisprudence, and would still have the safeguards of disciplining lawyers if their use of a trade name is false or misleading, if it implied connection to a governmental entities or to an individual who has no affiliation. And so there still is a safeguard for consumers.
Mr. Johnson, do you think that there will need to be ongoing revisions and work because of the lack of clarity about what might be false or misleading? I know you've done a tremendous, put in a tremendous amount of effort into that, but it seems to me with trade names, do you foresee a lot of discussion or litigation around that issue? I'm thinking about one in particular, and I'm going to use another animal, but there's a trade name out there that's El Abogado, let's just say cat, but the person using that uses a different trade name. Do you foresee that being an issue in a way that we've not thought about before?
We have seen in the process of putting these rules together, we've seen the wind blow in very different directions. And there were times when I thought that if we did anything on trade names, it would just topple the work of the committee entirely, whether it was related or not. And then other times, the wind's just entirely slowed down, and in the end, this part of the rules changes was passed by more than 78% of the voters. So I think it's hard to predict. I hope that lawyers use good judgment, but then if they don't, the disciplinary authorities need to act.
The thing about it is, I think that a lot of the statements that are made publicly would arguably be opinions.
Yeah.
And so what do you do about that? I'm the best in the world. Well, I guess that's my opinion.
As we say in the comments, that if your unsubstantiated statement is implying that there are facts that back this up and that quantify it, well, then you've gone too far. And if what you say is just fluff, like that you deliver legal services with a buzz, well, it doesn't mean anything in particular, and it's not provably false, and it's the type of statement that may be bad judgment, but it's not constitutional.
But it's not going to be the norm that the lawyer's going to say, and I guarantee this outcome. That's not what happens, and that would be perhaps easier to prove that it is misleading or not based on facts.
And in the comments that are relatively robust for the advertising rules, we hit on many different issues like that. In many situations, in the end, it does come down to an assessment of application of the law to the facts, and a judgment has to be made, and you can't sort of sum it up all in advance. But I think we've made the constitutional standard very prominent, and that will focus the CLE efforts and the articles, and then I think most lawyers get this, that anybody who's gone to law school in the past 40 years has studied the advertising Supreme Court decisions, and this all sounds familiar. It's not like a surprise, so.
Mr. Johnson,
yes,
you mentioned advertising that implies an affiliation with a state agency as something that could potentially be misleading. Is there any inconsistency between these adopted, the rules that you all are proposing that we adopt, with any inconsistency with the pending House bill that talks about a specific kinds of misleading advertising, like affiliation with a state agency or with a charitable legal organization? And do we need to be more specific about those two instances?
I will confess ignorance on what's pending in the legislature. I've heard only the least bit, my first impression would be we need to get the ethics rules right as a matter of constitution. We'll sort out whether the legislature gets something.
Well, just to the provision, and who knows what will happen because we're in the middle of the session, but the provision does contain the clause that it can't be modified by rules. So it would be the governing practice. And it basically says, you may not practice under a trade name that implies a connection with a government agency, charitable legal service organization, or that the firm, I think getting back to Justice Guzman's question, that the firm is something other than a private law firm. In addition to not being false, misleading, or deceptive. And it could be that those are just categories of false, misleading, or deceptive.
That's what I'm thinking, that it sounds like it might be permissible, constitutionally permissible clarification of what false or misleading is. That and my first reaction is those all sort of seem like the right ballpark. But yeah, my sense is the skirmishes will go on forever. We can't wait until all the legislative proposals and all the years have been debated. We need to come up with a good set of rules. I think this is a good set of rules that we ended up with. It's coherent and clear. Parts of it are quite familiar. Rule 7.02, it just carries forward provisions that have been in Texas law with regard to identifying the lawyer responsible for the placement of the ad, that allow board certification to be advertised in the way that it has been for the past decades. Because
Professor Johnson, I wanted to ask you about that rule in particular, because it seems like there's one significant change in the comments. It says in Rule 7.02b that you can communicate that you do or do not practice in particular fields of law. But then comment 3 seems to broaden that fairly substantially and say you can also say that you're a specialist, which is quite a change from our current practice. And so I was curious as to why the committee thought that that was advisable to allow people to say that they're a specialist when they're not board certified.
This is a long-running debate. I think the weight of relevant precedent and scholarly guidance is that if you specialize in certain areas, you can say that you specialize in certain areas. If the state doesn't like you saying that, they can require you to say more. And so they could impose a requirement saying you have to state that that you're not board certified. And we used to have that rule in Texas. And so going back to constitutional principles, if the statement only potentially misleading, then the remedy is more speech, not less. If it's inherently misleading, it can be prohibited.
So if that's the case, then why are we getting rid of the requirement to say that you're not board certified?
Well, yeah, that and that I don't know that we're not getting rid of it here. It left a while ago. I'm thinking it might have been in the early 2000s when there was some tidying up, but it might even go back to the 90s. So that requirement.
It didn't go back that far, because I remember when I was in practice up through at least 2010, people were still saying that. But it just seems like quite a change that doesn't seem necessarily to track what the rule says.
So with regard to a lawyer to state that they're not board certified in an area where they say they specialize, the state can do that. It would be rationally related, and it would, in my opinion, pass constitutional muster. I think there would have been a great deal of thought that the old rule that did require stating that one was not board certified made the legal profession look bad. That when those disclaimers had to be placed everywhere, which cast a shadow on good lawyers who were licensed to practice law, and so I don't regret that having gone away. But if the state wanted that, in my opinion, could do it constitutionally, and then see what.
Mr. Johnson, let's set aside the First Amendment objections to the prohibition on trade names, which frankly, I'm not sure are as meritorious as has been assumed, but just set those aside. What are the arguments that eliminating the prohibition on trade names is good for the profession or good for the public?
Often it's going to advance consumer understanding. If the trade name is one that is chosen that has content to it, such as Northside Construction Lawyers, well, it's useful for potential clients to know that this particular firm offers that area of services, and it would seem to be dubious to say, well, even if you practice construction law and even if you are really qualified, you can't say that. I think that would be questionable as to whether that was in the public interest. I realize that these are issues on which Texas lawyers and ordinary citizens have differences of opinion. I would say that in the rules vote, very strong vote was in favor of the advertising rules, including the reformulation of the trade name, turn upon whether or not it was false or misleading. So it's sort of interesting that there wasn't more debate in the public hearings we held. We did 3 big public hearings. I think they had between 1,500 and 2,500 lawyers in attendance at each. And the number of comments on trade names, as I recall, was negligible. Let me kill off 7.02. And so we still have the rule that if you advertise contingent fees, you have to disclose whether the client's liable for the expenses of litigation. And we now have a new provision in the proposal, which says that if you advertise a certain fee or fee range, then you must conform to what you have advertised for a reasonable period of time or for as long as you promised. So this would add some clarity to promises of specific fees. Shall I go on to solicitation communications, rule 7.03?
Please.
Two big changes in the rule dealing with the anti-solicitation rules. The first big change is that we've clarified that prohibition that has traditionally extended only to in-person communications, one-to-one, arm around the shoulder type of situations, it now will apply to telephone, social media, or other electronic communication that is live or interactive. When the lawyer's right there and is responding to the client and making the pitch, it's just going to be treated the same as an in-person communication. And so that will extend the well, it will create clarity about these types of communications in the digital age, and to some extent, it extends the reach of the anti-solicitation rule. On the other hand, we've added a provision that cuts back on the anti-solicitation rule, which says that that the rule does not apply to communications with an experienced user of the type of legal services involved for business matters. And so if a lawyer wants to talk to an experienced business person who is an experienced user of business legal services, you can do that in person. The rules don't need to protect that type of sophisticated, experienced individual from overreaching or undue influence. Then a few miscellaneous provisions related to solicitation communications. You can't make the communication misleadingly look like a legal document, like a subpoena or something. It must be plainly marked advertisement. We've followed the trend nationally with regard to allowing a nominal gift of modest value to somebody who refers a client, and so the emphasis there is on nominal. We have the rule that most states now that lawyer A will send personal injury cases to B, and B will send corporate cases to A, and it has safeguards. It can't be an exclusive arrangement. The lawyer has to exercise independent professional judgment, and the affected client has to know. There are traditional prohibitions against giving clients things of value, like advancing the cost of litigation or money for living expenses. So those rules remain in place. We have added what I think of as a cup of coffee exception. And that's because one of the lawyers at one of the public meetings said that what he likes to do with a potential client is to go out to lunch or sit at the diner and talk for a period of time, and wants to be able to pay for the coffee or the lunch, and that made sense to us. That something of nominal value, ordinary social hospitality would pass muster. Shall I go on to Rule 7.04?
Please.
Okay, so this is the rule that requires filing of advertisements and solicitation communications with the State Bar Lawyer Advertising Committee. So this is the reporting regime. That regime stays in place, and importantly, many lawyers told us the pre-approval process for advertisement stays in place. You can submit your ad 30 days in advance, get it approved, and not have to worry. Or before you go to the production costs of filming a commercial, you can submit the script and get that approved. And many lawyers thought that was very, very important, that made their life much easier. So all of that remains in place.
Professor Johnson, is it your expectation that the Advertising Review Committee will basically be a backstop for the trade name rules? Because when somebody's using a trade name, they're going to have to get it reviewed in their advertisements and solicitation communications, and then the review committee could say whether it's false or misleading?
Yes, I think that's quite right, that inevitably the trade name is going to come to the attention of the Lawyer Advertising Committee. And I assume they'll just develop expertise and standards and and have a consistent approach to dealing with these filings by thousands of lawyers. So 7.04, the filing regime stays unchanged. 7.05 greatly expands the exemptions from filing in order to minimize the burdens that are placed on lawyers. And so the first of those exemptions is with regard to bona fide nonprofit legal aid organizations. Again, we want those lawyers, doing their good deeds, serving the underserved. We don't want to burden them with filing requirements. Secondly, and I certainly didn't hear anybody in the public hearing process object to this, we would make all websites exempt from filing except for the homepage. Keeping a website up to date is its own burden. Having to file every part of that whenever you tweak some part of the website or add something, it just adds to the miseries of law practice. And so websites except for the homepage would be exempt. And then there's a list of things that are otherwise always exempt. And if you had a really bland homepage, you might even escape the need to file the homepage. In a broad range of cases, professional newsletters would be exempt. And then this one is really important. And this is with regard to social media postings. And do you have to file copies of your law-related social media postings? And what the rule does, it lays out a two-part test. It says that a lawyer is not required to file a communication in social media that does not expressly offer legal services and that is within a broad range of categories. So informational, educational, political, artistic, or made for entertainment purposes. And so what this would mean is that to a large extent, if you have not made the pitch offering legal services in your social media posting, that then there's a pretty good chance that no filing is required. And if you have made the pitch, well, then you're not going to fall under this exception, and you may not fall under any other exception, and you may have to report it. And this sort of makes sense that where the lawyer expressly offers legal services, we want to be paying attention to what's going on there. And the advertising committee can review that. If you don't expressly offer legal services and you're in one of those five broad categories, then you're okay. And sort of a clear working rule. And then the final provision in advertising, 7.06, it just carries forward beautifully drafted language from the prior advertising rules. And it talks about how if you violate the advertising rules, then you can't provide the representation to the client who's attracted, so you're disqualified. And then the second part is that, and neither can any lawyer in your firm provide the services to the client who's attracted by the violation of the advertising and solicitation rules. So we have disqualification, imputed disqualification, and then there's a further limitation saying that if the case is referred to somebody else, the fee can't be split with the lawyer who violated the advertising rules. And all of this was very nicely set out in the current Texas rules, and we just carry that forward. So that's the package.
Further questions of Professor Johnson? Thanks very much. Last presentation is on reporting professional misconduct and reciprocal discipline for federal court and agency discipline. Mr. Chairman, can I begin?
Thank you, Chief Justice Hack. We have, actually, I got the easiest one, I think, here at the end. It's the simplest, really requested by the Chief Disciplinary Counsel's Office to close a loophole, in my words, that extends a lawyer's duty to report discipline by another jurisdiction into federal agencies and federal court systems that are not necessarily jurisdictions or courts. So that you think of the immigration bar, maybe the patent bar, they have their own disciplinary processes. So the previously or currently, the lawyer didn't have to report that like they might if they were disciplined by the state Supreme Court of Nebraska or some trial court in Arkansas. So this really just extends that to federal agencies and federal courts other than the typical federal court, and adds the definition of discipline. Make it clear that we're not talking about some sort of administrative slap on the wrist for using the wrong form or failing to pay your dues or something like that. So the simplest one, I think, the easiest. Got a few questions actually during our education tours, but I think most of those questions were satisfactorily addressed, and people were not as afraid of this as possible. Maybe they just don't want to admit they may ever face discipline somewhere else, and they just thought that it will never apply to them. So why not vote for it, right? But that's it. If there's any questions on this one, happy to answer them, or any other of the rules.
Any questions?
I have one that goes back to trade names. We heard the comment that that's a majority position to allow them. What are the data, if you know?
In terms of which states?
Or not necessarily which, but how many jurisdictions allow trade names?
I believe all but two. I may have to tag Professor Johnson to address that, but right now we're down to, I think that Texas and one other still have not made that change. There were 7. There were a bunch of lawsuits filed pretty much all at the same time, federal courts in each of them. As you may recall, the one in Texas, I believe, is abated while this process plays out. But I think we're down to 2.
Other questions?
Back to the diminished capacity rule. Do the comments or does the rule itself make it clear that it's applicable to existing clients and not to new representations?
I will double check that and make sure, but the main thing is it starts with the definition of a client as opposed to a prospective client. And that was sort of the implication. I believe that's also what the ABA's implication or definitions infer. Now, ABA has a prospective client rule that Texas is just starting to consider, but the idea being that this is about an established relationship. And I thought we addressed it in the comments. I can real quickly double check. We know that in an adjudicatory proceeding, there are other protections, civil or criminal. You've got often the judge's assistance, whether if you're appointed to represent someone or named as an ad litem of some sort, then there are already some protections built into that process. And there often would be an attorney ad litem and a guardian ad litem appointed in those types of scenarios. The comment, I believe, I'm pulling it up now. Again, it continues to refer to the client, the normal client-lawyer relationship, and is affected by a diminishment of capacity. Doesn't say specifically, this does not apply to people who are not your client yet.
Or existing. I mean, it doesn't need to say as much as that, but perhaps existing client, because the rule itself says to make adequately considered decisions in connection with the representation. And I don't know that that necessarily captures existing representation. But that's just something to think about in considering the comments that I know y'all are going back to do.
Absolutely. Thank you.
Other questions? Well, that concludes the presentations that we had scheduled. And we thank all our presenters, Chair Kynard, Mr. DeClue, Professor Johnson, for addressing the rules and responding to our questions. We also thank the bar for its hard work and the committee's work on these proposals for years, both in drafting and vetting and presenting to the bar, and now us today, is really extraordinary. And we know that you do this out of devotion to the profession and its discipline, and we're very grateful for all of your efforts in that regard. We also thank our staff for its work in preparing for today's deliberations, especially the court's rules attorney, Jacqueline Domery, our paralegal, Pauline Easley, and clerk of court, Blake Hawthorne. And we're grateful, as always, to Casey Kennedy, Director of Information Services at the Office of Court Administration, and Kelly Thibodeau at OCA for their assistance with production. The court will issue an order soon that will reflect our votes on the proposed amendments. And if there's nothing further, the deliberations are concluded and we'll stand adjourned.
Thank you, everybody.